Welcome everyone to the Richard Cooper Memorial Lecture for 2021. For those of you who don't know me, my name's Rick Bigwood. I'm the Dean of the Law School at UQ. I'd like to begin by acknowledging the traditional owners and the custodianship of the various lands on which we are severally located this evening. I pay my respects to their ancestors and their descendants who continue cultural and spiritual connections to country. I recognise their valuable contributions to Australian and global society. I'd also like to acknowledge distinguished members of our audience, in particular the Honourable Justice Sarah Darrington, who is physically in attendance this evening, the Honourable Chief Justice James Allsop AO, the Honourable Justice Darryl Rangier, President Fleur Kingham of the Land Court of Queensland, and the Honourable Justice Timothy McAvoy, each of whom is joining us remotely. By way of background, the annual Richard Cooper Memorial Lecture is a joint initiative of the UQ Law School and the Federal Court of Australia. The series was established in 2005 in honour of the late Justice Richard Cooper of the Federal Court of Australia, who passed away suddenly on 14 March 2005. The series is dedicated to the strong interests in maritime and native title law that Justice Cooper developed over the course of a long and distinguished legal career. Unfortunately, Justice Cooper's widow, Penny, and their sons, Sean and Ben, are unable to attend this evening, but nevertheless send their best wishes and appreciation for the law school's continued support of Justice Cooper's memory through both this memorial lecture and the Richard Cooper Scholarship administered annually by the school. Now, it gives me considerable pleasure to welcome and introduce you all to the Honourable John Dowsett AMQC as the speaker for this year's Richard Cooper Memorial Lecture. President Dowsett was appointed as President of the National Native Title Tribunal in April of 2018. His Honour has a distinguished legal career. He first became a barrister in 1972, shortly after graduating from the University of Queensland with degrees of Bachelor of Arts and Bachelor of Laws with honours. He was appointed Queen's Counsel in 1982 before being appointed a judge of the Queensland Supreme Court in 1985. President Dowsett was then appointed a judge of the Federal Court in 1998. In June of 2012, President Dowsett was named a member of the Order of Australia for services to the law and to the judiciary, to professional associations, and to legal education in the area of litigation and dispute resolution. President Dowsett's lecture this evening will address aspects of the Native Title Act 1993 and approaches taken in the implementation of that Act. His lecture is titled "The Image and the Search: An Idiosyncratic View." There will be an opportunity for audience members, both in person and online, to ask questions at the end. And so, without further ado, I welcome President Dowsett to the lectern to address you.
I first must apologise to you for my address. I had a rather heavy fall on Monday night, and I'm finding it very difficult to put a coat on, let alone tie a tie, but I hope you'll forgive me. It's by no means meant to be an act of disrespect. I am both grateful and honoured to have been asked to deliver this address. I worked with Richard over a number of years and still admire him greatly. In a moment, I shall say a little more about him, but before doing so, I should say something about the picture, which is now on the screen. It shows a cardboard cutout of a character from the Star Trek movies. I understand the character to be Jean-Luc Picard, played by Patrick Stewart. I say that I so understand because, as far as I'm aware, I'm the only person in the Western world who has seen neither The Sound of Music nor any of the Star Trek series. However, in my chambers in the Perth Court building, I have this cardboard cutout. What is its significance for present purposes? You may be able to discern Bob French's signature at the bottom of the picture and dated 24 December 1998. Bob was the second president of the tribunal from 1994 to 1998. He was and is noted for his quirky, perhaps whimsical, sense of humour. This cutout was his farewell gift to the tribunal members and staff when he left. Perhaps I should explain it to you. The tribunal is frequently referred to by its initials NNTT. Bob, having the benefit of some mathematical training, expressed the abbreviation NNTT as NT squared. He then urged our people to, quote, keep on trekking, such trekking being the pursuit of the objectives of the Native Title Act and, perhaps ominously, warning that he would be watching them from another dimension, meaning at that time the Federal Court, as the court responsible for judicial review of tribunal decisions. Of course, he later moved to yet another dimension as Chief Justice of Australia, from which point he watched not only the tribunal, but virtually all Australian judges and many other tribunals. Before the pandemic, I invited Bob to the tribunal in Perth for drinks and took the opportunity to reintroduce him to his cardboard cutout. They were pleased to catch up. Bob's subtle message highlights the early aspirations of the tribunal, particularly its awareness of the large task which it was undertaking and the very public and not always favourable profile which it was to enjoy, if that is the right word for it. Bob was both encouraging and warning. His work in the native title area, in the tribunal and in the Federal Court has been fundamental to the development of the law associated with native title and our procedures for dealing with it. You might think that I have said too much about Bob and not enough about Richard. In my own defence, I say only that Bob's example and his amusing quirkiness say much about the approaches to native title taken by the Federal Court and the tribunal since the very early days. It was a new area of judicial and administrative work, requiring explorers and adventurers who were willing enough and brave enough to push the known boundaries of legal learning and practice, taking risks where appropriate. Just as Bob and his message reflected and still reflect those characteristics, so did Richard and many of my other colleagues from those early native title years. Richard Cooper died in early 2005, and so there have been many of these lectures dealing with either native title or admiralty law. In the course of such lectures, much has been said about him. I met him first at university. He was a year or so ahead of me, but nonetheless, we got to know each other, probably through the Law Student Society, now I think the University of Queensland Law Society. I seem to remember, as a member, opposing the name change. I can't remember why. After graduating at the end of 1971 and completing articles, I spent a year as a law clerk trying to get my court reports done. At the end of 1972, I took chambers. Richard was already there. He had been articled to Ted Lennon, whilst Ted was a partner at Lippitt & Co., and they had ended up in chambers at the bar together with others, including one Paul de Jersey and Adrian Hayworth-Smith. They were all supportive and encouraging. After I had been there for about a year, Richard left practice to work for the Commonwealth Attorney General, I think Lionel Murphy. John Byrne joined the chambers. When Richard returned to practice, he went to other chambers in the new MLC building, as did I, although we were no longer in the same group. The move to the MLC building was a major event in the history of the Queensland Bar. The heavyweights of the bar were no longer accommodated only in the old Inns of Court. Many of them went to the MLC building, attracting us juniors to follow. That change has never been reversed. I was appointed to the Supreme Court in 1985. Richard was appointed to the Supreme Court in 1989 and went to the Federal Court in 1992. Susan Kiefel joined me on the Supreme Court in 1993 and went to the Federal Court in 1994. I went to the Federal Court in 1998. So the three of us played an extended game of musical chairs over a period of some years. The profession was relatively small in those days, and such mobility was more common than it now is. However, our shared experience on the Supreme Court may have influenced the way in which the Federal Court subsequently handled native title cases, particularly in Queensland. I shall return to that theme. On the screen, you will see a photograph depicting Richard presiding over the Wick determination conducted at Arakoon on the 13th of October 2004. The next screenshot can only be described as a demonstration of joy following that event. It needs no further comment. I should say something about my title, The Image and the Search, an idiosyncratic overview. It is always difficult to choose a topic for a presentation such as this. The difficulty frequently arises out of the fact that one is asked for the title before the paper is written, and frequently before the speaker has reached any decision as to its content or even its theme. There is also the temptation to choose a catchy title, even if it eventually has nothing to do with the content. In the present case, I decided that I wanted to say something about the legislation, that is the Native Title Act, something about the tribunal, in other words, a public relations exercise, something about the history of the Native Title Act, particularly concerning the court and the tribunal, and something about the future. The miscellaneous nature of my approach is reflected in the reference in the title to idiosyncracy. The words, the image and the search require a little more explanation. The image may be the ultimate, perhaps ill-defined outcome, which we hope to achieve in implementing the Native Title Act, and perhaps a wider outcome concerning reconciliation and Australia's future. The search is for clarification of those goals and the identification of ways in which we might achieve them. I shall return to this theme. However, as I pondered the title, I suspected that I had not invented it, that I had derived it from some source which I could not identify. So I looked up the phrase on the internet, of course, and discovered that it was the title of a novel by an author called Walter Baxter. He had also written a better-known novel entitled Look Down in Mercy, published in 1951. In reading the article on the website, I saw that in the early 1950s, he had been prosecuted in the United Kingdom for indecency in relation to the publication of The Image and the Search. I then realised that I had read that book when I was about 15. I came across it by accident in a second-hand book collection acquired by my parents in circumstances which I can no longer remember. Thinking back, I'm not surprised that the author had, in the early 1950s, been prosecuted for indecency, although I doubt that the book would attract much attention today. He was acquitted. Anyway, notwithstanding my juvenile adventures with raunchy books, I assure you that there will be no more of that tonight. Turning to the legislation, anybody who was not directly involved in the drafting of the Native Title Act and its initial implementation might wonder why particular aspects of it were adopted. One might expect to find some assistance in that relatively unusual feature of legislation, the preamble. However, this preamble is not really a preamble to the Act. It is rather a statement of national aspiration, going far beyond the scope of any one piece of legislation. Although it acknowledges past wrongs, it says little about how we might achieve our aspirations, apart from by the enactment and implementation of the Native Title Act. I shall return to the preamble at a later stage. One is inclined to jump to the conclusion that the original drafters did not fully understand the problems which they were addressing or perhaps creating. However, that would be a typical example of the benefit of hindsight. The reality is that the drafters were faced with massive political problems leading to inevitably pragmatic solutions, owing as much to politics as to a desire to achieve worthwhile goals. Pragmatic solutions, when enshrined in legislation, frequently pose problems for those who are charged with implementing that legislation, particularly the courts and the tribunals, the legal profession and the public service. Two examples of such difficulties arose in the early history of the Native Title Act. They require a little explanation, but they are interesting in themselves. However, before addressing those matters, I should say something about the tribunal's present functions. As I have said, the public relations exercise. The Act is, to say the least, complex. It became more complex when the 1998 amendments inserted the various sections from 24AA to 24OA dealing with ILUAs, that is, Indigenous Land Use Agreements, and future acts. These sections might well be described as the terrible 24s. One major function prescribed by the Native Title Act is the maintenance of three registers: the Register of Native Title Claims, the National Native Title Register, and the Register of Indigenous Land Use Agreements. In fact, this function is not performed by the tribunal. The Native Title Registrar is responsible for that function. Curiously, however, the president of the tribunal may give directions to the registrar regarding the exercise of her powers. All of the tribunal staff, not including the statutory office holders, that is the president, the members and the registrar, are provided by an organisation called the Federal Court Entity. It supports the Federal Court, the recently combined Family Court and Federal Circuit Court, and the Tribunal. The Tribunal makes staff available to the registrar for the performance of the registration function, such staff being provided to the Tribunal by the Federal Court Entity. The registration function is obviously of considerable importance. The Native Title Register is probably the easiest to understand. It contains a record of all determinations as to the existence of native title by the High Court, the Federal Court, or in some cases, certain state or territory bodies. The purpose of that register is obvious. The other two registers are a little more complicated. The Register of Native Title Claims contains details of determination applications filed in the Federal Court or given to certain state or territory bodies if an application contains an assertion that a person or persons holds or hold native title. The importance of this register is that registration confers upon the relevant applicant certain procedural rights, particularly the right to negotiate. The registration process is complex, involving a careful examination of the extent to which the applicant has complied with the requirements of the Native Title Act. If the registrar refuses to register, the matter may be reconsidered by the tribunal or reviewed by the Federal Court. The Register of Indigenous Land Use Agreements is, as the name suggests, concerned with Indigenous land use agreements, or ILUAs. Again, the registration process involves careful scrutiny in order to ensure that it complies with statutory requirements, particularly as to the making of the agreement. Registration gives statutory effect to such agreements. I should add that the registered agreements frequently do not disclose the full extent of agreement between the parties concerning matters related to native title, which one might think seriously reduces the purpose or undermines the purpose of the register. Perhaps the major part of the tribunal's work is generally described as Future Act work. For present purposes, a Future Act is a proposed grant of rights by government, usually in connection with mining, which grant will affect native title rights and interests by extinguishing them, or which is otherwise wholly or partly inconsistent with the continued existence, enjoyment or exercise of such rights and interests. Validity of certain future acts depends upon subdivision P of Division 3 of Part 2 of the Native Title Act. Broadly speaking, the relevant government must give notice of its intention to perform a future act, that is, to make a grant. A native title party may assert the right to negotiate in good faith with the proposed grantee and the government. It is entitled to do so in certain specified circumstances, which circumstances relate to the likely effect of the proposed grant. Much of the work in this area involves our deciding whether or not any of those circumstances is likely to occur. If so, the parties must negotiate in good faith. Generally, our work concerns smaller miners. The larger miners are more likely to avoid the need to engage in this process by entering into ILUAs. Most of our work in this area comes from Western Australia. It is performed by the president or one of the members. In other words, the work is being done at the highest level, yet it involves relatively simple questions. One is inclined to suspect that this procedure was part of a trade-off with the states designed to ensure that the right to negotiate will only arise if there is something about which to negotiate. If there is no negotiation, or if the negotiation fails, a party may ask the tribunal to determine whether the act may be done, and if so, the terms upon which it may be done. We have relatively few of these future act determinations, as we call them. However, they can be difficult. They too must be undertaken by the president or a member. Reasoned amendments conferred upon the tribunal a third discrete function. Pursuant to section 60AAA of the Act, the tribunal may assist in promoting agreement about matters relating to native title or the operation of the Native Title Act, as between registered native title bodies corporate, or between common law holders, or between such a body corporate and a common law holder. At its simplest, Such assistance may involve the supply of readily available information. On the other hand, it may involve extended mediation. There are difficulties with this function. They arise out of the complex structures frequently set up to manage native title interests, often resulting in the effective exclusion of holders of the registered native title body corporate and the common law holders from decision-making, or even knowledge of the ways in which their native title is being utilised. Such complexity may create a situation in which a common law holder has a genuine grievance, but such grievance is not actually with the relevant registered native title body corporate, but with some other entity. In those circumstances, Section 60AAA will not be engaged. The tribunal has numerous other functions. One involves the provision of assistance to native title representative bodies in the performance of their functions. There are also the assistance provisions in the Terrible 24s to which I have referred. Another function may arise out of referral of a matter to the tribunal by the Federal Court or by the relevant Commonwealth Minister for review or inquiry. The tribunal may conduct conferences or hearings for the purposes of such reviews or inquiries. This function has not been frequently exercised, at least until quite recently. In 2019, the court sought our assistance and my assistance effectively as a referee to consider issues arising out of conflicting native title claims over the city of Cairns and its surrounds. I acted with an anthropologist. That process took about 9 months. More recently, the court has asked us to assist in conjunction with a representative body in facilitating meetings of groups having interests under an ILUA, which ILUA has proved to be unfit for purpose. That process has to date also involved substantial amounts of time. You may get the idea that much of our work is directed towards matters of process rather than substantive issues. That is partly true. However, in my view, early events in our native title history hollowed out the originally intended functions of the tribunal. The resulting hollow has not really been filled on any principled basis. 2 examples from the tribunal's history help to explain this hollow. One story relates primarily to the Federal Court. The other relates to the court, the tribunal, and the political process. Obviously, I have very close ties to both the court and the tribunal, and to the many people I have worked with in both institutions. I do not mean to be critical of those institutions or those people. However, some unidentified politicians may be fair game. My own experience with native title started when I went to the Federal Court in 1998. I was told that my appointment to the court in Brisbane was the product of there being available funding for additional native title judges. In those days, the Federal Court never missed an opportunity to leverage the suggestion of new jurisdiction into additional funding. However, it did not follow that I would actually do any native title work, and I did not do so for a number of years. The reason for this was that very little native title work was being done. I was told by older and perhaps wiser colleagues that nobody wanted native title cases decided. Nobody, apparently including the traditional owners, the various governments, graziers, miners, developers, and the general public. If that proposition were true, then the stakeholders in question certainly got their money's worth. A judge in each registry was calling over the cases in each registry every 6 months. In Brisbane, there were about 200 cases, hence they did not get much attention. At or about that time, a few high-profile cases were decided, but the vast bulk of the work was largely untouched. The idea that courts could happily maintain a long list of cases, which cases were going nowhere, was not new. Until the mid-1980s, many of the state courts were holding on to hundreds, perhaps thousands of personal injuries cases, many of which had been settled but not discontinued. Others were expected eventually to settle, whilst a very small number would go to trial, but in a time frame usually set by the plaintiff's solicitors, sometimes having regard to their wish not to earn too much more money in the current tax year. However, from the mid-1980s, the state courts had been changing their ways, becoming more inclined to push the cases towards resolution by agreement or trial. The Queensland Supreme Court was particularly active in that regard. The Federal Court was still quite new. It did not have a backlog and rightfully prided itself on being speedy and efficient in the disposition of cases. However, in the late 1990s, native title looked like changing that. In the Brisbane Registry, we came to the conclusion that the current position was, even in the short term, untenable. Although I did not think about it at the time, I have recently concluded that the change in approach in Queensland was, at least in part, attributable to the experience of the three judges who had come from the Supreme Court with this new, more interventionist approach to case management. With the enthusiastic support of other Brisbane Federal Court judges, we established an ongoing case management regime involving biannual callovers in regional centres, at which callovers were sought to make orders which would advance matters in the general direction of negotiated outcomes or trials. Such steps were frequently small, but they had significant incremental effect. In so doing, we established relationships with the various stakeholders. They made it clear to us that they wanted the cases resolved, preferably by negotiation, but if not, at trial. The court's conventional wisdom had been wrong. How did it become an article of faith that nobody, not even the traditional owners, wanted native title claims to be determined? I think that in part it was attributable to a perception that there would be a change of government and that the new government might favour legislative amendments which would make it easier for traditional owners to obtain determinations. As far as I could see, there was no evidence justifying that perception. I suspect that there was also a reluctance to take on the apparently Herculean task of managing and disposing of this very substantial workload, so different from our other existing areas of jurisdiction. In the end, it seems to me that instead of identifying a goal and appropriate strategies for achieving it, we allowed ourselves to adopt an apparently attractive alternative course in which we effectively didn't do very much. I should say, however, that from about 2003, things started to change. The judges became as proactive in native title case management as we were in other areas of the court's work. However, our industry led to my second story. After that memorable statement, as you know, in Mabo number 2, Chief Justice Mason and Justice McHugh said, in the result, 6 members of the court are in agreement that the common law of this country recognises a form of native title which, in the cases where it has not been extinguished, reflects the entitlement of the Indigenous inhabitants in accordance with their laws and customs to their traditional lands. After that memorable statement and publication of the accompanying reasons, it was inevitable that questions of traditional ownership would be resolved in accordance with Australian common law and statutory law. Further, given the long history of decisions concerning the exercise of the judicial power of the Commonwealth, it followed that the recognition and enforcement of native title would be very much within the province of the courts. However, those who drafted the Native Title Act apparently thought otherwise. That Act, in its original form, established the tribunal and prescribed a mechanism pursuant to which it might, in some circumstances, including where the application was unopposed, make a determination, which determination could be registered in the federal court. Upon such registration, the determination was to acquire the status of a court order. In other words, it seems to have been expected, or at least hoped, that disputes would be generally resolved by mediation in the tribunal, followed by formal recognition in the federal court. As you will be aware, the High Court held in Brandy that a similar mechanism was unconstitutional on the ground that it had the effect of vesting judicial power in a body which was not a Chapter 3 court. Although at least some of the circumstances giving rise to that decision in Brandy occurred as early as 1990, the High Court delivered its judgment in April 1995 after enactment of the Native Title Act. In Form Island and Selpam, the full federal court, of which Justice Cooper was a member, held that similar provisions in the Native Title Act were unconstitutional and for the same reasons. Obviously, the decision in Form Isle deprived the tribunal of much of its anticipated workload. The Act was amended in 1998 in order to resolve the constitutional problems. However, some of the oddities of the Native Title Act in its current form are remnants of the previous legislation. It seems likely that Parliament intended that pursuant to the 1998 amendments, the tribunal would assume responsibility for mediation, subject to the court's overall supervision. There was an inherent problem in adopting that course. Since the early 1980s, the courts and the legal profession had been developing case management practices which utilised mediation to resolve disputes which would otherwise go to trial. By 1993, mediation was effectively an element of case management used extensively by the courts. However, as I have said, Parliament initially established the tribunal as, in effect, a mediating body in the expectation that it would foster agreements which would be registered in the federal court. After the decision in 4 Mile, the 1998 amendments inserted Division 1B into Part 1 of the Act. Section 86A was, in effect, a charter for mediation. In effect, Section 86B provided that unless the court otherwise ordered, each native title application would be referred to the tribunal for mediation. The court could only order that there be no mediation if it were satisfied as to certain matters. Similarly, it could only terminate mediations if it were satisfied as to certain matters. For as long as the court was not actively managing cases, it did not matter much that there was effectively compulsory mediation in the tribunal. However, as I've said, in about 2003, the court started serious case management of native title cases. Thereafter, there was a real risk that compulsory mediation in the tribunal would disrupt case management in the court, largely because of conflicting timetables and varying degrees of optimism concerning the possibility of reaching a mediated agreement in a particular case. There was at the time a perception of unacceptable delay in the tribunal's mediation process, which perception may or may not have been correct. Because of this view, and in order to avoid possible disruption of the case management process, the court frequently withheld or withdrew cases from mediation so that case management could proceed uninterrupted. On other occasions, the court referred matters for mediation by mediators other than those available in the tribunal. In so doing, the court utilised mediation provisions in the Federal Court Act and in the rules. Fairly clearly, the court was seeking to avoid the risk of conflict between mediation in the tribunal and the case management in the court. But in so doing, it created the possibility that 2 mediations might be running simultaneously, one in the tribunal and the other pursuant to court order. The tribunal seems to have understood, probably correctly, that the 1998 amendments were designed to give it a monopoly over mediation in native title matters. However, the court had at that time and has, I think I've lost my place. Sorry. However, the court had at that time and has considerable, and still has considerable influence in connection with the drafting of legislation relating to its own practice. These and other matters led the government in 2005 to commission a review of native title claims resolution, including the conduct of mediation. The 2 persons charged with the review reported on the 31st of March 2006. They disagreed in their recommendations. They couldn't have disagreed by any greater margin. One recommended greater flexibility for the court in relation to native title dispute resolution. The other proposed that the tribunal have an exclusive mediation role. The government accepted the latter proposal. Such acceptance led to the enactment of the Native Title Amendment Act 2007. One of the asserted reasons for adopting that recommendation was avoidance of simultaneous mediation in the tribunal and elsewhere. Other asserted reasons included the promotion of better communication between the court and the tribunal, probably fairly unlikely, improvement of the effectiveness of tribunal mediation, perhaps unlikely, and facilitation of improved behaviour by the parties. I have no idea what that means. In effect, mediation in the tribunal was given priority over case management in the court, contrary to the previous approach which focused upon case management, of which mediation was an aspect. It is fair to say that the court was not happy about the new arrangement. Late in 2007, the government changed. However, it was not until the Act was further amended in 2009 that the tribunal's monopoly on mediation was terminated and mediation was effectively placed under the control of the court as part of its case management function. So it has remained. Clearly, there were strong conflicting views as to the respective roles of the federal court and the tribunal. It is not clear why they should have been so. It has been suggested that persons associated with the tribunal had disproportionate influence in connection with the matter. However, my own observations throughout all my time on the court suggests that in matters of practice, its recommendations were and are generally accepted by governments of both political persuasions. It may be that those who were in 2007 responsible for legislative decision-making did not appreciate the potential complexity of native title law, the difficulties inherent in the traditional decision-making processes of Aboriginal and Torres Strait Islander peoples, and the factual complexity associated with their relevant laws and customs. Those responsible for the 1993 Act and the 1998 amendments seem also to have overlooked these matters, perhaps considering that the relative informality of mediation proceedings would help traditional owners to participate in the decision-making process and or save money. At least with the benefit of hindsight, that view was misconceived. The 2007 decision makers apparently also failed to realise that the decisions in Form Island Brandy led inevitably to the vesting of responsibility for the conduct of native title cases, particularly applications for determinations as to the existence of native title in a Chapter 3 court, in this case, the Federal Court. Such courts are essentially in charge of their own proceedings. It was also foreseeable that the High Court and the Federal Court had much more to do in developing the principles underlying the earlier High Court decisions. That task could only be performed by those courts. There is still much work to be done in connection with the operation of the Native Title Act. We are, for example, only starting to address the question of compensation. The closer we look at that matter, the more complex it appears. At the moment, the representative bodies and the states and territories are seeking to identify an efficient way in which to develop the relevant jurisdiction in this area. Other areas require further consideration. Since the early days, there have been concerns about accountability for funds derived in connection with the exercise of native title rights and interests, particularly negotiation rights. It is a sensitive matter, but it will have to be addressed. There are also serious issues concerning the relationships between traditional owners and the registered native title bodies corporate. As I have said, such relationships are frequently complicated by complex corporate structures or trusts, which seem to concentrate control in the hands of small groups of traditional owners with or without the involvement of necessary or unnecessary experts. The concept of holding native title rights and interests on trust, as contemplated by Section 56 of the Act, seems also to require further consideration. Other concerns relate to funding. Many native title bodies corporate have little in the way of funding, whilst others are quite wealthy. Hence, it is difficult to know how to deal consistently with such bodies. Resolution of these and other problems require sensitive handling. Well-intentioned advice may frequently be or be seen as being paternalistic. Those of us who make decisions from time to time, that is most of us, like to think that in making such decisions, we follow a rational process, identifying the problem and then considering the ways in which it might be solved. However, I find that not infrequently, my response to a problem is intuitively to identify a solution, perhaps based on past experience, without carefully identifying the problem. Indeed, sometimes I find myself identifying the problem in terms of a preconceived solution. This mistake is frequently encountered when somebody comes to you with a problem and a possible solution. We too readily take the line of least resistance. The two stories previously mentioned may well reflect a failure to identify and deal with the real problem. In addressing the future, I want first to say something about the preamble to the Native Title Act. The preamble is well written and has a very highly desirable quality of brevity. However, what does it really say? First, it recognises the dispossession of Aboriginal and Torres Strait Islander people. Second, it outlines our acceptance of international human rights and anti-discrimination conventions and declarations and the enactment of associated legislation. Third, it identifies the effect of the High Court's decisions concerning native title. Fourth, it asserts the view that the Australian people intend to rectify past injustices and fully recognise Aboriginal and Torres Strait Islander peoples and their diverse cultures. Fifth, it asserts the need for certainty about questions of invalidity arising out of the existence of native title and for appropriate compensation arrangements. Sixth, it asserts that a special procedure is necessary for the just and proper ascertainment of native title rights and interests, where possible by consultation, or where not, quote, in a manner that has due regard to their unique character, end of quotes. Further, governments should facilitate negotiations. The emphasis upon such matters was based upon assumptions which were inconsistent with the Federal Court's decision in 4 Mile, having regard to the High Court's decision in Brandy. Seventh, the preamble recognises that traditional owners will need funding in order to pursue their claims to native title and or compensation. Such funding is available, but is available in quantities that are generally not thought to be adequate. Eighth, the preamble recognises that some Aboriginal and Torres Strait Islanders may be unable to establish traditional ownership and that they should be compensated in some way. Finally, the preamble provides that the Native Title Act is intended to be a special law for the descendants of Australia's original inhabitants, designed, as I understand it, to advance those descendants in order to ensure that they will equally enjoy and exercise human rights and fundamental freedoms. The aspirations identified in the preamble go well beyond the recognition and protection of native title. And yet the only concrete step identified in the preamble, broadly speaking, is enactment of the Native Title Act. Of course, we know that governments, particularly the Commonwealth, have many other programs for the advancement of Aboriginal and Torres Strait Islander peoples. However, the preamble seems to assume that the Native Title Act is the solution, not simply one of the more important steps towards a solution. I suspect that, at least in part, this emphasis on the Native Title Act is based upon the perception that the identification and protection of native title has the unchallenged and unchallengeable imprimatur of the High Court. Recognition of the continued existence of native title necessarily requires that there be a workable process for identifying and protecting the relevant rights and interests. Hence, the political cost of legislating in this way was minimal. A second consideration may well have been that any document which presented a comprehensive approach to overall reconciliation and resolution of economic and social disadvantage would look very much like a treaty, a circumstance which may well have raised serious political difficulty, as it still may do. One cannot doubt the good intentions of governments at all levels in seeking to address the extraordinary inequalities which Aboriginal and Torres Strait Islander peoples face. However, are we asking the correct question at the most fundamental level? Surely, the real question should concern expectations and intentions as to the nature of our society as a whole. In 50, 100 or 200 years from now, our society has changed in many ways since 1945, when our non-Indigenous society was made up of people who had come or whose families had come from the British Isles. After 1945 and until about the mid-1960s, our society was augmented by immigration from continental Europe. This was followed by increased immigration from Southeast Asia and other parts of Asia, Africa and the Pacific Islands. Since 1993 or thereabouts, we have sought to locate Australia's original inhabitants within this already complex society. In 1945, our society had deep roots, and to some extent they still exist. They include the English language, our Commonwealth ties, parliamentary democracy, and at least nominal Christianity in all its forms. Although these landmarks still stand, they are not as dominant as they were. Further, they inevitably mutate in ways which probably cannot be controlled. We may hope that the future Australian society will be an eclectic mix of ethnic identity, history, values, and culture, comprising one identifiable people, but with mixed roots. Alternatively, that Australian society may be divided, with various groups defending themselves against the possibility that their ethnicity, history, values, and culture will be lost in a greater whole. Making the right choices now will determine the cohesion or cohesiveness of our future society and necessarily the quality of life for future generations. Thank you.
Thank you, President Dowsett, for an informative and highly reflective and at times highly amusing as well talk. I very much enjoyed it. I was chuckling away there, even though I wasn't drinking wine. So, but thank you. I think you honour perfectly the intention of the memorial lecture series in honour of Richard Cooper. So I thank you for that. We've got 10 or 15 minutes to take questions if there are any. I take questions from the physical floor or from the virtual floor. The virtual floor, I hope, will come to me via email. I've got someone doing that. But are there any from the physical floor for President Dowsett so far? Nothing coming through.
They may be typing. They may be typing.
Must be too comprehensive.
It happens.
Let them go and have their way.
Well, I might actually wrap it up a bit early, if that's okay. I mean, off camera is a wonderful spread of delights and wine. I didn't want to be cruel to mention it, so I won't. But thanks, everyone, for your attendance. Thank you again, in particular to Professor Dowsett for an excellent lecture for 2021. I wish you all well, and certainly those in person. Something's come through the chat, I see.
Oh, we got
Yeah,
a
all
question.
good.
I told you we're coming.
Yeah, here we go.
Is there any way that the NT Act will include a self-determination component, or to that extent?
Self-determination about what?
Is there any way the NT Act will include a self-determination component, or to that extent?
Does that mean determination as to membership of a particular descent line, or does it relate to the associated question of title?
We're going to have to wait.
I'm inclined, I may not be answering the question, but I'm inclined to think that there is not much likelihood of any revision of the current system for determining traditional ownership. I think that would be too controversial. But if I haven't understood the question, perhaps you can try again.
With clarification.
Yeah, a question.
This is what online teaching's like. This is my kind of normal for us. I think we'd be better at it by now.
After 2 years of online teaching, you are living the dream there, Rick.
Look, again, I'll complete again with my my formal thanks for giving you time for it. Oh, hang on. Indigenous self-determination, where TOs are able to be in the economy on the traditional land. That might make sense.
Well, of course, if there's been a determination, then it's a matter for the traditional owners, according to the determination, to decide who can go on the land. I don't think there's any reason now why traditional owners can't go on the land. It's, but perhaps you're talking about land that is occupied under leasehold or something like that.
Coming up. Sorry.
Building, mate.
Oh yeah, okay. Well,
Finally, they find
I think that a number of traditional owners are doing that, and quite a number of traditional owners throughout the country who have got their determinations are making decisions and are acting in a way that involves the development of profit-making undertakings. And an example in Queensland is Quantanuka over on Stradbroke Island, where there is extensive investment. They, in some ways, have made enemies of other people who have decided they don't really like the fact that it looks to be successful. But that's certainly one example, and there are many others, particularly in West Australia, where there are very large, and the activities there are being fostered by, are being supported by very large amounts of money paid by mainly miners to the traditional owners for the use of the land, and that money is then used in industry that imposes, that employs, I should say, native title. The same thing happens in North Queensland with a number of the areas up there using their land for profit-making exercise through giving employment to traditional owners. I don't know that I could say any more than that, really.
Another
We're gonna have to six.
Yeah,
Seven.
Comment. Do you believe there will be any changes to the native title system in the light of the destruction of the Yuccan Gorge caves?
I don't think that there will be a major change in the legislation. However, I am sure that there will be a major change in the way in which projects of that kind, sites of that kind are considered. It's not just a matter for the Commonwealth, it's also a matter for the state. Without wishing to be unduly harsh about the West Australians, but the West Australians are where a lot of this trouble comes from, mainly because they've got so much development, not because of anything particular about their act, but because they have so much individual development going on. I think that the provisions relating to whether or not acts should be allowed to proceed will be accompanied by rather more substantial negotiation provisions. And I think the other thing about the gorge is that there really was a miscarriage. The process just miscarried quite seriously, and you can never really be sure that a process won't miscarry. But I'm quite sure people will try to make sure it doesn't happen again. And we've seen a fair bit of feedback about it already.
Look, I think I might make the third attempt. So thank you very much for those online questions. We have a small token appreciation for your talk. By the weight of it, it's not one of Nick Gaskell's books. So that's a good sign. We require a much larger bag for that. So again, thank you everyone for your virtual attendance and your in-person attendance. Thank you, President, again for your wonderful talk, and hope your arm heals up well. I invite those, at least in present here today, to enjoy the Bloom Festival as you depart after imbibing and eating the wonderful food that they can't see on. So I bid you farewell, and thanks again.